So, hey, I'm Bill Gross, the LA Probate Expert. And if you know, I've been really talking a lot lately about the probate advance industry. And I'm really excited to have here not just a smart guy, but a professor, university law school professor, David Horton from UC Davis's Law School, who's published several articles, law review articles on the subject. And I really appreciate the chance to maybe get a little flavor. So, Professor Horton, thank you so much for making time for us today.
Oh, thanks for having me.
Just a little curiosity, what was it that got you interested in the topic in the first place? Of all the things in the world, you're a law professor, to think about all the law and possibilities. What was it about that got you interested to spend the time and make that at least a passion project, but not academic project, for the last few years?
So when I was practicing, I handled a fair number of probate cases, and every once in a while I would see one of these cash advance transactions. And I was just so curious because it was unlike anything that I had ever seen before. I never actually was involved with a client or an estate that took out any kind of a probate advance or probate loan, but I saw enough of them that my curiosity was piqued. And then, years passed, I ended up going into academia, and I discovered that there was this really contentious debate about litigation funding. This was about a decade ago, where there were these companies that would buy stakes in pending civil cases, and they'd set things up so they only recovered if the plaintiff either won a verdict or recovered a settlement. But there were all kinds of objections to the practice. People saying it was predatory. People saying that it fanned the flames of litigation. And then it just kind of occurred to me that this probate lending phenomenon I had seen was a little noticed sort of version of this same thing as litigation lending. So that's what made me start looking into it.
So in the probate case, were you attorney doing probate administration? Were you doing probate litigation? Both? Where did you fit into that as a practitioner back then?
Right. So I did, estate planning, administration, and litigation. But because I had come from a federal clerkship, I was really sort of litigation focused. So most of what I did was actually litigation.
Got it. And so by definition, then, financing litigation, or in this case, advancing heirships, a portion by definition is financing litigation, right? I mean, if you're getting an advance for the purpose of hiring an attorney, or if an attorney is getting an advance or financing to pay for the law fees, by definition, that's creating litigation. The question is it creating good or bad litigation, right? That's really what we're talking about here.
Yeah, definitely. So I find this so interesting. In the litigation funding, scenario where you're talking about plaintiffs with civil cases, I think there's a pretty good argument that a lot of the payment is going to fund litigation or to encourage litigation, because very often it is funneled into the plaintiff's case. But in the probate context, it's much less clear, because very often you just have these heirs and beneficiaries who seem to want to get the money early from an inheritance, but they're not necessarily going to put it back into suing anybody. They may be using it for, some good purpose, like, preventing a foreclosure on their house or getting surgery. They may use it for some bad purpose, or, not bad, but not necessarily necessary purpose, like they may just splurge and spend it all.
Right.
But it's different than litigation funding in the sense that you don't really have the money necessarily going to fuel litigation.
Right. That's the question, is it going for something that's beneficial or not?
Yeah.
So in the course, so everybody's watching this, the advance is the case where somebody who stands to inherit or thinks they're going to inherit gets advance money by a company that believes they're going to inherit money, and takes a piece of that in advance, sometimes a year or two in advance of when they may get it, or longer, depending on what that is, and they may do anything with it. So in your course as a attorney, did you have clients who got these advances and misused it that you saw? Did you see some that used it properly, or is it just more a matter of you saw it in the case file and you weren't personally involved in the process?
Yeah, it's really just the latter. So when I was practicing, I really only had sort of passing familiarity with the probate loans. And then when I did my research on the topic, I was frustrated by the fact that I very often could not figure out what the heirs and beneficiaries who took out these loans were doing with the money.
Correct.
So there were some instances where for whatever reason, it was obvious from the court records. And, sometimes it seemed to be that, a legitimate purpose or a purpose that seemed socially valuable. Like I mentioned, preventing a foreclosure on property. That was one thing that I saw. And then I also saw situations where I couldn't tell for sure, but I was almost positive that the heirs and beneficiaries were just sort of hypnotized by access to easy money.
Sure.
So there's a bunch of cases where someone would take out just a series of loans over and over and over. And then another family member would learn about this and they'd start taking out their own loans,
Right.
and dozens of these loans in the files. And you can't help but think that these are people who just, want to blow through their inheritance before they actually get it.
Now, one thing that you did, first off, just for those who want to follow up, and I'll link to your articles in the notes, you actually did mathematical scientific research of cases, of legal cases, but they're all in San Francisco County. Now, in my experience, your data matches up pretty well with Los Angeles. I almost exclusively in Los Angeles County. So I would say it certainly looks similar, and I've pulled the data and kind of see kind of the same things that you did statistically. So you actually, though, took it another step, which was rather than merely the legal consequences or procedures, you actually took data of actual cases and then analyzed that. So what was it? I mean, again, I in my prior years, I was a student of research and law reviews. Normally, they're more philosophical or more scholastic. That's not the right word, but more theoretical, where you really took a scientific approach that I might see in a social science journal or some others. What was it that prompted you to do the data? I loved it. It was fantastic. But what was it that prompted you to take that step and really get scientific about it?
Oh, thanks. Well, I was lucky enough to have a colleague who actually is next door to me in the UC Davis Law School, who's a very skilled economist. And, we were just talking.
There we go. It looks like an economist research. Now you say that makes sense. I'm sorry, go ahead.
Yeah, right. So, we were just talking about what we were working on, and, she got really interested in this phenomenon. I had previously, pulled a bunch of court files, first from Alameda County, California, and then from San Francisco County, California, to do projects that were about other types of issues. And they were empirical projects in the sense that they were based on the court data I had pulled, but they weren't very sophisticated because I don't have a background in econometrics, but my colleague did. And so, working with her on the first of these articles, I was able to, do things, or we were able to do things that I certainly couldn't have done on my own. For example, she can run regression analyses to try to see whether any of the variables that we have access to explain why people take out loans in the first place.
Right.
And then also to see whether or not the fact that there's been one of these loans actually increases the probability of litigation. So it was really helpful to be able to, drill down and really sort of understand the correlations that we had access to.
It was also fascinating to see kind of like the population's lifetime of these loans, right? Because you do one at a time. I'm in the business, and we do one at a time as they come up. But to see kind of a whole population, say, well, gee, on average, they stay on the books this long. This is how many they get paid. So it was fascinating. So when you do this work, we'll go back. On the legal side, or I should say the more kind of traditional argumentative side, you also point out that California has some unique regulations that require these be filed with the court that make them really public record. Anybody can see. And oftentimes one heir sees the other, and they're not talking to each other, but as a result, like you say, they'll go to the advance company, get money on their own. So you seem to point out that California has maybe not only more regulations, but it seems to be a more positive scheme of regulating this. And then you also mention, which I think is true also, that the judge can always do whatever the judge wants to do. The judge, if they felt it was abusive, they can just say, hey, you're not going to pay that off, and it's going to magically disappear. So let's talk about from a California context. Do you feel like there's enough, after all your research, do you feel like there's enough regulation on the books about it, and it's more about education, or do you feel like there's some regulation that's missing in the process?
Yeah, that's a great question. I think the California statute, which is, as far as I know, the only statute in any state that regulates probate lending, I think it does a lot of things right. So, among the things that it does that are right, the fact that it requires these loans to be filed in the probate record is great because it increases transparency.
Yeah.
And then I think it's really good to have judges have the ability to, decide that one of these transactions is just too extortionate and to refuse to enforce it on that basis.
Right.
I also think it's really great to give probate judges this power rather than having the heir or beneficiary need to bring a separate civil case to challenge the validity of one of these contracts, as you'd have to do without the statute, because the case is already in front of the probate judge, so it doesn't really add any steps. I personally think that the legislation is a little bit too permissive. I feel like it really depends on heirs and beneficiaries sort of being proactive and raising the issue of fairness in the first instance, when very often I think, courts, if they looked at most of these transactions, would see red flags. So, if I had my druthers, the legislature would amend the statute to make judicial review of these transactions mandatory, rather than something that only occurs when an heir or beneficiary raises an objection. But I think it's certainly, the statute in California is certainly better than nothing.
The other thing I think that might be, I was just kind of floating an idea, I'm curious to hear your feedback. Having gone through the exercise myself, and you see certain cases, certain companies, you can imagine that if the data was more available, for example, mortgage data, which is public record, there are mortgage companies that will pull your mortgage and say, oh, you pulled it back when you did a mortgage last month when rates were 7%. If rates ever go back down to 5%, they're going to solicit you and say you can save money. And that, I think, can work to the consumer's benefit. I would think in a case like this, if in addition to the record, the document being filed, if there's a way to put the metadata, the amount of the advance, the dates, the times, the payback number, that would create more competition, which I think ultimately would work well for the beneficiaries or heirs who take out these loans. There'd be companies who would just resolicit all of them at half the price and refinance them and save them some money. I think that's why the companies approached me to say, can we help them do that? I said, yeah, that sounds like a great idea. Why not? What do you think? Have you looked at that, or is that something that came up, or is that a problem, do you think?
Yeah, no, that's a terrific idea. And the thing that makes it slightly more complicated, at least in my view, is that if you are, dealing with a traditional mortgage, then, it's very clear when the deadlines for payment are, when the mortgage will be paid off, what the actual interest rate will be, what the number of payments will be. The thing about these probate loans is that you really never know exactly what you're getting because of the fact that, the effective interest rate that these companies earn is linked to how long the probate case lasts. And very often nobody has any idea how long that will be, because some cases are smooth and some cases have all kinds of unforeseen problems. So I think it's a wonderful idea to try to increase transparency and to get market competition, which really doesn't seem to exist in any way, as far as I can tell. And then, it's just, if you can figure out a way to do it, I think that, would be wonderful.
Well, I don't work for the state or the county, but I think there's ways that could be done. But a little on my pay grade. I'm just selling houses as a broker. I showed your research to an industry company, and they had a argument on your data. I was curious how you would respond, and I know that's part of the publication process where people raise arguments and you answer them. So the argument was that you took your data from a period of time, like a certain set of cases. I forget the years that opened on a certain year, and for like 2 years or so, and you analyze those that closed. But by definition, that you weren't able to capture the data of those that opened then that had not yet closed, or those that opened before you capture the data that still were not yet closed. And the proprietor said to me, that's where we lose the money. That's where the costs are, right? The ones that open and close, of course, those are great rates of interest. It's the ones that don't close for 2, 3, 4 years or 10 years, that we have to monitor and track and sometimes participate in. Have you had that argument, and how would you answer that? Therefore, while I think your analysis is very insightful, it doesn't give a complete picture to the financial costs of this business.
Sure. So here's the thing. That argument is actually not a correct description of the research, because what I was able to do in the several projects was take a look at cases that opened the whole probate case opened at a certain period of time. And then I have access to all the filings in all those cases. And that includes cases in which loans were taken out, but the probate case remained open. So I actually do bake that into the analysis. It's actually part of the cross-section of cases that I'm looking at. I can tell, and there were just a handful, but I did find some cases where the probate estate triggered loans, and yet the loans had not been repaid because the estate was still open. So even when you do look at that,
right,
I find that almost all the time,
yeah,
not only are the loans repaid, but the lenders are fully reimbursed for not just the amount of the principal, but the extra fees or interest that they charge. So I totally acknowledge that it is possible that estates go off the rails and lenders don't make a profit, or maybe they take a total haircut. It does happen, but it rarely happens, at least in the data that I have.
The other argument he mentioned was that unlike a lender where you send out a monthly statement or it's all electronic, that to monitor these cases does require a higher level of underwriting by an attorney, as well as individually, as well as sometimes administering to keep their claim going to court and making appearances, of course, nowadays online. You don't really get the cost side of it. Obviously, it's going to be higher than collecting credit cards, but there's no way to estimate that. But I think your numbers would indicate the ratios are still so high, there'd be room for that, right? Is that your basic contention?
Yeah, so I agree with absolutely everything that you said. So, on the one hand, that's a very valid point that these companies not only are assuming, a fair amount of risk, because anything can happen during the probate process, but they do have to sort of, be more active in order to protect their investment than
Right.
traditional lenders. And
Right.
that's evident by the number of cases in which the probate lenders filed litigation in order to protect their interest, because, say, the administrator of the estate is not doing a good job.
Right.
And in that way, when the lender steps in, it's actually beneficial for everybody.
Right.
So, completely point taken. I completely agree with that.
To your side, though, I would say also, having brought multiples of these to companies to underwrite, they don't take a case that's 90% sure because they're getting such a huge markup at 100% markup. They're looking for 100% cases. At least they believe it's 100%, or they believe it's 99.99%. And I think to me that kind of speaks to, well, there you go. I mean, if they're taking cases that were unsure, and they took 5 of them and 4 closed and 1 didn't, but they don't. They really are looking for 99.9% sure as much as they can be on these things. So I think that at the end of the day, that works out well. What was surprising also was you had a list, I'm not sure you got it from, in your footnotes, of, I want to say, about 25 or 27 companies. Now, I've tried to create an exhaustive database. I don't remember how many you had and how many more I added. I only found a couple maybe that you didn't have. And of course, your review articles are a couple years old now, so maybe they started since then or renamed themselves, new names and such. Surprised me though how few are active. I mean, I saw your research, and I've been in this business a little bit, and I thought, wow, these people must be making a fortune hand over fist. And they're all like anonymous. When I try to reach out to them, they didn't respond. Did you ever reach out to some of these companies for comment or review? And did you find what I find, or did you find something different?
Yeah, right. Okay, so first of all, yeah, I agree. So my anecdotal impression is that I am surprised that it doesn't seem like the market has exploded in terms of the number of companies. That is not what I would have expected at all, but it does seem to be the case.
Right.
In terms of reaching out to the companies, so I have to go through a special process called IRB review before I can try to contact any human being about a research subject. So I haven't done that. So I can't reach out, but I had at least one company reach out to me. And it was very interesting to talk to this company and its president about their business model, about what they feel, about why they feel that what they do is, just and equitable. And, I definitely learned a lot from it. I'd be very open to getting more of a perspective from the lenders.
Yeah.
Yeah.
It'd be interesting to hear what they had to say. I mean, it'd be fascinating to get like I don't know, you call me people in a room and you watch them, interview them, and video it. It'd be fascinating to watch the dialogue, I think.
Absolutely. Definitely. I'm sure I would learn a ton about what to actually do what they do. rather than just have the outsider's perspective that I have.
Now, because I'm a full-time real estate broker focused on probate, this is a regular topic I deal with all the time, and I do my best to, like everybody, to do the moral thing and the right thing, and to use the tool properly and not use it improperly. And I'm sure people can stand in judgment, one way or the other. But I know that you're a law professor, you're not a real estate broker, you're not in the probate space anymore as an attorney on a daily basis. But I also know that you've moved away from doing research on this topic. What was it? It just wasn't, well, let me actually ask you straight out. Why is it that you no longer are looking to continue your research? Because I found it fascinating. I'm sure that you need more subscribers than me to make money at this or to make a career out of it. But what was it that moved you away from it?
Well, thank you for the compliment. And, the truth is I just felt like I ran out of things to look at or things to say. So I published 2 full-length articles and 1 shorter article in an online law review, all of which involved empirical research about probate lending. And, basically, the articles tried to answer the same questions, and they kind of reached, in my mind, the same conclusions, which is, here that lenders make a pretty sizable profit, that if you conceptualize their products as loans, they're charging enormous interest rates, that they face almost no risk of coming away empty-handed because the loans are almost always repaid. And then, I just got to the point where I felt like, okay, all the arrows are pointing in the same direction, and I don't have any new data source to use or any new angle. So I think I'm just going to hang up the spikes for a while.
Okay. Well, look, if you ever want to get back into it, look at other counties, other states. I would love, I think I spoke to you about this and volunteered. I'd be glad to help any way I can, providing data, resources, because I find it a fascinating topic. I'm not sure what else there is to find. I think, your data in San Francisco is consistent with what I've seen in Los Angeles. I think it's the same kind of numbers. When I didn't do it quite as mathematically accurate as you did, but just pulling up a spreadsheet and a quick review of things, it looks about the same. So I don't know they have anything to add other than the breadth of the industry and the fact that I do think there's room for more regulation as far as transparency. I think that would be tremendously beneficial. And I think I just kind of gleaned that from your article and then kind of thought, well, what would that look like? And I'd be certainly glad to flesh out anybody who's interested in that. So, well, great. Well, I really appreciate your time, Professor Horton. I just don't know how much to thank you. My father was an attorney. My parents' dream was for me to go to law school and be an attorney. I applied and got accepted and decided not to go to law school. And so for the last few years, I've been playing like an attorney in the probate space. But to actually speak to a law professor and share these findings with the people, it's really a privilege for me. And I just want to thank you so much for your time today.
Oh, thank you so much. It was really nice to talk to you, and I wish you the best of luck.
Thanks so much.
All right. Take